In December of 2020, executives of Ripple were sued by the SEC under the claim that they conducted an illegal securities offering through the sale of their cryptocurrency token XRP by claiming it was an unregistered security. The underlying premise behind the lawsuit is that Ripple believes that XRP is a virtual currency and as such is not subject to securities regulations, whereas the SEC argues that XRP is a security and as such is in violation of an illegal securities offering. But what does this all mean? This video will go in depth into what exactly defines the argument of each case and what the lawsuit means for the crypto industry as a whole, depending on who actually wins the case. No matter what, the fate of this lawsuit will alter the way the crypto industry works as we know it. Now, before we dive any deeper into the weeds about this lawsuit involving Ripple and XRP, we first need to understand both of them. Ripple started as RipplePay.com in 2004, and in 2012 the company was handed over to OpenCoin, which took the company towards the route of the Ripple Payment and Exchange Network, and a few years later in 2015 was officially changed to what it is known as today, Ripple. Today, Ripple is a global payments network with some of the world's largest banks serving as its customers. Notably, Bank of America and PNC is a few of them. For those that just want a simple TLDR version of what Ripple is, Investopedia puts it well by describing it simply as a blockchain-based digital payment network and protocol with its own cryptocurrency XRP. Ripple's main process is a payment settlement asset exchange and remittance system similar to the SWIFT system for international money and securities transfers, which is used by banks and financial middlemen dealing across currencies. Okay, maybe not too much of a TLDR, but it's a good explanation of Ripple nonetheless. Unlike almost all other blockchains that are heavily or entirely decentralized, Ripple's network is far from decentralized and somewhat centralizes things by using a consensus protocol, which eliminates the need for mining of the cryptocurrency and also means it is not a proof-of-stake system or a proof-of-work system. While anyone can download its validation software, it maintains a unique node list that users can choose to verify their transactions based on which participants they think are least likely to defraud them. The consensus protocol in place also eliminates the potential for double spending to occur. The token used on this blockchain is none other than XRP, which serves the purpose of an intermediate mechanism of exchange between two currencies or network as a sort of temporary settlement layer denomination, a vital aspect to the entirety of the Ripple blockchain XRP ledger as a whole. However, the system that is utilized by some of the biggest companies in the world is at risk if the SEC proves successful in their lawsuit. Now, that may have been confusing, but now we can get back to the important part of the video, the lawsuit. As previously mentioned, the SEC charged Ripple executives with violating investor protection laws by raising $1.3 billion through an unregistered securities offering. Quote, "This claim was made since Ripple sold XRP tokens to fund its ventures in 2012 when it was first released. As stated earlier, the SEC made claims that the XRP token is not a virtual currency, but rather an unregistered security. While several other currencies currently operate in gray area that the SEC could easily attack and claim are part of securities rather than virtual currencies, the main reason that Ripple is being attacked with XRP, according to the SEC, is due to the centralized nature of XRP's ledger and corresponding blockchain. The SEC argues that Ripple violated the first rule of the Howey test as an investment of money. Now, what exactly is the Howey test? The Howey test refers to the U.S. Supreme Court case for determining whether a transaction qualifies as an investment contract and therefore would be considered a security and subject to disclosure and registration requirements under the Securities Act of 1933 and the Securities Exchange Act of 1934. Under the Howey test, an investment contract exists if there is an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others. Now, the first case of the Howey test happened for a company in Florida that sold plots of land with citrus groves located on the premise. The company then let buyers lease the land back to the company, which would cultivate the orange groves, sell the oranges, and give some of the profits back to the buyers. From this case, the Supreme Court settled on a four-prong approach to identifying securities. 1. An investment of money. 2. In a common enterprise. 3. With expectations of a profit. 4. To be derived from the efforts of others. So these are very important in determining if cryptocurrencies could be classified as securities. Now we've heard the SEC's argument as to why Ripple is guilty, but what is the counter argument that Ripple says? Well, obviously, Ripple Labs chair members claim the sales were legal. Their argument also references the so-called Howey test, in which Ripple acknowledges the sale of XRP took place, however, argues that it does not meet the criteria of the Howey test. Specifically, Ripple argued it did not meet the first rule, which requires an investment contract, contrary to the SEC's claims. Ripple also claimed they were given no fair notice that their actions were in violation of securities law. The SEC itself has actually admitted that no statement was made on whether XRP could be classified as a security before filing its case. Additionally, Ripple claims that the SEC is making classifications based on bias rather than actual merit or even well-defined rules for that matter. And also claim their operations are not at all distinct from those of other platforms that have been given a pass in regards to being considered a security. Now, it doesn't take a super genius to realize that both sides are biased towards the case falling in their favor, and as such, each side has their own prospective interests. Even if one side knows deep down that they are in the wrong, they are going to hold true to their claims like a dog on its favorite chew toy. Now, all these claims were made at the start of the lawsuit in 2020. The lawsuit is still going on, and it's now 2022, so there's been some time for new watershed moments to have come to light. But what are those watershed moments? So it's obvious that the preliminary claims are the bread and butter of the lawsuit, but there's also a surplus of information being released. For example, just recently, a few days ago, Ripple gained an upper hand on the SEC as the judge hearing the case between the two entities ordered the SEC to hand over the Hinman documents. These documents mainly relate to a speech in which the previous SEC director said that Ethereum was not a security. Documents in which the SEC had been withholding up until now. They actually are being released one day after the recording of this video for Ripple to access. Unfortunately, they are not becoming public yet. While this isn't the first time the SEC has gone after companies in a similar manner, most companies sought after by the SEC are quick to settle. But the reason that the Ripple vs. SEC lawsuit has gained so much traction and attention is due to the fact that Ripple decided to fight the claim, while also claiming that certain SEC members turned a blind eye to similar cryptos due to past involvement in them, notably Ethereum, which funded its operations through an ICO, which could easily classify it as a security. The fact that Ripple now has access to these documents can potentially be a game changer in the lawsuit, putting the proverbial nail in the coffin to the SEC. However, we can't be quick to go to assumptions as we don't know what the Hinman documents truly reveal, and so we can only draw speculations from this point forward. While there's still much debate between the two sides and neither side plans to lose anytime soon, the lawsuit is suspected to be in its final stages, with a final outcome suspected of being decided within the next 3 to 4 months. Or at least that is what Ripple's CEO has claimed. The SEC, not surprisingly, is trying to extend the lawsuit in hopes of getting more evidence to help the case turn their way, as from outsiders' perspective, it appears that Ripple has an upper hand, and hopefully for the crypto industry, is preparing to RKO the SEC once and for all. However, again, no decisions are made at the moment, and speculations is our best form of information, which is not a very good form of information. No matter the decision that will be made on this lawsuit, it will set a major precedent for the future of cryptocurrencies as a whole. If the SEC ends up victorious, it will spell danger for an exponential amount of other cryptocurrencies. But if Ripple ends up victorious, it will show the overreach that the SEC tried to exert and how they don't have the power to influence the cryptocurrency market and industry like they thought they actually did. Only time will truly tell the outcome of this monumentous case.